Today on lawcaseuk.com, I'm looking at the House of Lords decision in the 1991 case of R&R. The case involves the marital exemption to the offence of rape, and I consider the case to be one of the most interesting that I've analysed so far. It's interesting because it presents us with a set of facts which are obviously abhorrent. But the question that it asks us in relation to those facts may not be the one that we want to answer. If asked the question, should those facts be criminalised, then the obvious answer for us is yes. However, in the case of R&R, the court was not faced with the question of whether they should be criminalised, but really with the question of whether they were already criminalised. And that is a different question for us. It is a legal question that the court had to face. Now, as well as looking at the domestic decision in the case of R, I'm also going to be looking at the resulting European litigation, and therefore the case features in both the criminal and constitutional sections of this website. Now, looking at the domestic first, of course, the question of general public importance that the Court of Appeal certified for the House of Lords to decide in R was as follows: is a husband criminally liable for raping his wife? And in the case of R, the House of Lords unanimously answered yes to that question, and Lord Keith was responsible for delivering their judgment. Let's look at the facts to start with. There was little doubt on the facts in the particular case. The husband and wife were together until the wife left the matrimonial home and she went to live with her parents. During this time, both parties to the marriage had mentioned to each other consulting solicitors with a view to divorce. Then, some 22 days after she had left the matrimonial home, the husband forced his way into her parents' house and attempted to have intercourse with her against her will. Now, he admitted the facts. He was charged with assault and attempted rape. He claimed that the attempted rape should be regarded as consensual due to the matrimonial exemption to the offence of rape which existed within the common law. Of course, he had no similar defence to the simple charge of assault. So those facts I would highlight are very much indicative of a marriage that is already breaking down. And if you stay with me until the end of the video, I will suggest that this aspect of the case should have featured more prominently than it actually did. But before then, in terms of our analysis of the case of R, I think we can say that the House of Lords had three questions that it needed to ask. One, what was the common law on the issue? Two, had that common law been affected by a statutory intervention? And three, what was the proper role for the courts in making or changing the law in these circumstances? Now, this third question I'm going to be calling the separation of powers issue, even though that phrase is not referred to in the judgment. But let's begin with the first question. What was the common law on the issue? Now, the start point for considering this question is a pronouncement by a former Chief Justice, Sir Matthew Hale. Now, he wrote a piece entitled The History of the Pleas of the Crown, and in that he was taken to have laid down an accurate expression of the common law at the time that he was writing. Now, Hale died in 1676, but his work was not published until 1736. But as I say, he was taken as providing an accurate reflection of the common law at the time that he wrote. And specifically, this is what Hale had to say in his history. He said, "The husband cannot be guilty of rape committed by himself upon his lawful wife, for by their mutual matrimonial consent and contract the wife hath given up herself in this kind unto her husband, which she cannot retract." And I emphasize those words, which she cannot retract. Now, that point was put more succinctly, perhaps, in the 1822 edition of Archbold, where it simply said, "A husband cannot be guilty of rape upon his wife." Now, in the present case, Lord Keith accepted that Hale's proposition represented the common law of England. But he said this. Now, this is a long quote, but it's really important to our understanding of where the House of Lords are coming from. Lord Keith said this: "The common law is, however, capable of evolving in the light of changing social, economic and cultural developments. Hale's proposition reflected the state of affairs in these respects at the time it was enunciated. Since then, the status of women, and particularly of married women, has changed out of all recognition in various ways which are very familiar and upon which it is unnecessary to go into detail. Apart from property matters and the availability of matrimonial remedies, one of the most important changes is that marriage is, in modern times, regarded as a partnership of equals, and no longer one in which the wife must be the subservient chattel of the husband. Hale's proposition involves that by marriage a wife gives her irrevocable consent to sexual intercourse with her husband under all circumstances, and irrespective of the state of her health or how she happens to be feeling at the time. In modern times, any reasonable person must regard that conception as quite unacceptable." So, Lord Keith says, yes, Hale was right at a point in time, but the common law is capable of evolving to reflect changing social circumstances. Now, in reaching his conclusion about common law evolution, Lord Keith relied quite heavily on the 1989 Scottish case of S and HM Advocate. Here, the Scottish court had similarly found no justification for the supposed immunity of a husband. Now, as well as looking at that key Scottish case, Lord Keith did review the English jurisprudence. And when he looked at those cases, whilst he did find some opposition to Hale's proposition in the 1808 case of Clarence, he only really found the exemption being disapplied in cases where exceptions were established due to some estrangement or separation within the marriage. For example, the 1974 case of O'Brien, where the court ruled that a decree nisi had the effect of revoking the implied consent within the matrimonial contract. And you remember I said earlier that I thought it was important that in the case of R, there was a marriage that was beginning to break down. And I'll return to that, as I said, at the end of the video. Now, having recognised that there were exceptions to Hale's proposition, Lord Keith did say, however, all English cases had paid at least lip service to the existence of this exemption. But he then went on to say that because there had been some departures from the proposition, there was no good reason, in his opinion, why the whole proposition should not be held inapplicable in modern times. And so that's the decision it makes. When you look at Hale's proposition, as I highlighted at the time, it looks like that it does not admit of any exemption. It is impossible for consent to be withdrawn. But the court do go on to find exemptions to that proposition. And what Keith says, well, is if you can have exemptions to that proposition, you can sweep it away in its entirety. And Lord Keith decides, of course, that the common law at a point in time is out of step with the modern concept of marriage. So in answer to the first question, what was the common law? It was once, as Hale stated, but had since evolved to allow exception, and in fact by 1991 had evolved to such an extent that it reflected the modern view of marriage, and therefore a man could in 1991 be criminally liable for raping his wife, whether or not the marriage had broken down. Now the second, and in my opinion the least interesting of the three questions, turns on whether Parliament had precluded the courts from removing the exemption by its use of the word unlawfully in the first statutory definition of rape. Now, the first statutory definition of rape was provided by the Sexual Offences Amendment Act of 1976, and it included this word unlawful. Now, of course, if by the use of that word the Parliament had precluded the courts from changing the law, then of course there's nothing they could do about that, because they were bound by an act of a sovereign parliament. Yes, of course they could vary the common law, but not when they became bound by statute. At least that's the way the traditional orthodox Dacian view would go. But in this case, the House of Lords decided, as a matter of statutory interpretation, that the Parliament, by the use of the word unlawful, had not intended to enshrine this matrimonial exemption into statutory law. So that was that. The House of Lords was not bound by any other interpretation of the statute. Now, the third issue, this separation of powers issue, as I termed it, this aspect I think is interesting, because here we move from a criminal case into one that has constitutional law aspects to it, because having decided that Parliament had not constrained the courts by the wording of the statute, Lord Keith then dealt very quickly with this issue. This is an issue that had been dealt with in much more detail by Lord Lane in the Court of Appeal, and Lord Lane had recognised that the role of the court here could be open to criticism. In particular, he said this, he was worried that the action the court was likely to take would go, quote, beyond the legitimate bounds of judge-made law and trespass on the province of Parliament. In other words, the abolition of a rule of such long standing is a task for the legislature and not the courts. There are social considerations to be taken into account, the privacy of marriage to be preserved, and questions of potential reconciliation to be weighed, which make it an inappropriate area for judicial intervention. So he recognised that that was a potential criticism of his judgment. But he answered that by saying as follows: the remaining and no less difficult question is whether, despite that view, that being the criticism, this is an area where the court should step aside to leave the matter to parliamentary process. This is not the creation of a new offence, it is the removal of a common law fiction which has become anachronistic and offensive. And we consider that it is our duty, having reached that conclusion, to act upon it. And therefore, so Lord Lane is happy that he's identified the criticism, but that he has a justification for acting in the way that he proposes. But if we go back to the Lords, Lord Keith merely said that he respectfully agreed with what Lord Lane had said. So in that regard, I'm a little disappointed that Lord Keith did not say any more on this constitutional issue. But there you go. Now, as a postscript to the domestic aspect of the case, Parliament has since removed the word unlawful from the definition of rape, and it did that in the 1994 Criminal Justice and Public Order Act. So that precludes any further argument that the House of Lords was wrong on this point. And in fact, Parliament's removal of the word tends to support the House of Lords' conclusion that it was surplus to requirements, or as the House of Lords said, surplusage, which is a great word, but not one recognised by my spell checker here. So that ends the domestic aspects to the case of R. But I am amazed that it featured no discussion on the respective nature of the decision that it reached, because of course it is a principle of the rule of law that the law should not be retrospective, and that principle is enshrined, for example, in Article 7 of the European Convention of Human Rights. Now, the House of Lords decision means that Mr. R was covered by the law of rape at the time that he attempted to have intercourse with his wife. However, it could be suggested that he did not know this until the House of Lords informed him of this in their judgment, which of course occurred after he had already committed the acts complained of. Now, if we look at it from his viewpoint, the marital exemption had been upheld by the Court of Appeal in a 1987 case of Kowalski, and also around this time there were other first instance decisions which were taking place. One of those, which is the case of Crown and C, did go the same way as the case of R, but the other case, the case of Crown and J, upheld the marital exemption, largely because, unlike the House of Lords, the judge at first instance felt that he was bound by the statutory intervention of Parliament in 1976, but also because he thought there was an important general principle that the law should be clear and that a person should not be convicted on the basis of decisions that are made on the law after the events complained of have taken place. Now, whilst I don't suggest there should be any sympathy for Mr. R, I do suggest that there was a legal question that needed to be answered. And this legal question, this one of retrospectivity, was the one that gave rise to the European jurisprudence. Why it didn't feature in the 1991 domestic litigation, well, one reason was, of course, that the Human Rights Act was not in at that time, so there was no actual discussion on Article 7 in the case. That wouldn't have precluded discussion, but it would have, of course, made a difference to the judicial landscape at the time when it came to considering these matters. So if we look at the international level now, the European level, shortly after the case of R was decided, there were two further prosecutions that involved men who had raped their wives. And in both cases they were convicted largely on the basis of the House of Lords decision in the case of R. Now, each of the men applied to the European Court of Human Rights for a determination that the United Kingdom had breached Article 7. The cases are the case of SW and the United Kingdom and CR and the United Kingdom, and they're bound up together and both decided by the European Court in 1995. Now, in terms of a reminder, Article 7 says that no one should be guilty of a criminal offence on account of any act or omission which did not constitute a criminal offence under national or international law at the time when it was committed. Now, the Strasbourg Court says that it follows from this that an offence must be clearly defined by law. And so this begs the question, was the offence of rape for married people clearly defined by law at the time that these men were convicted? And in fact, when we look at the case of SW, his case preceded, or the events that he was accused of preceded the case of Crown and J, which I've already mentioned, and which affirmed the marital exemption. So in that case, the exemption was in existence. Also, when Parliament amended the 1978 Sexual Offences Amendment Act in 1988, they had a chance to address the exemption, but they did nothing about it then. So one imagines they thought that it was preserved. Indeed, in September 1990, the Law Commission had recommended that Parliament abolish this exemption. So this august body clearly thought that the exemption was in place. However, their recommendation was overtaken by events because, of course, the House of Lords then reached their decision in the case of R before Parliament could act. But despite this evidence or argument to say that the decision in R was a retrospective one, the European Court of Human Rights sided with the National Court. And in reaching its decision, the court noted that in the first instance it was for national courts to interpret and apply national law. No rocket science there, you might think. And they said this: and there will always be a need for elucidation of doubtful points and for adaptation to changing circumstances. Indeed, in the United Kingdom, as in the other convention states, the progressive development of the criminal law through judicial lawmaking is a well-entrenched and necessary part of legal tradition. You might think there a nod from the European Court in particular to our common law tradition. And so the court decided by a majority of 11-6 that there had been no breach of Article 7. In particular, it said this: the UK decision did no more than continue a perceptible line of case law development, dismantling the immunity of a husband from prosecution for rape upon his wife. There was no doubt, under the law as it stood on 18 September 1990, that a husband who forcibly had sexual intercourse with his wife could, in various circumstances, be found guilty of rape. Moreover, there was an evident evolution which was consistent with the very essence of the offence of the criminal law through judicial interpretation towards treating such conduct generally as within the scope of the offence of rape. This evolution had reached a stage where judicial recognition of the absence of immunity had become a reasonably foreseeable development of the law. In effect, ladies and gentlemen, he should have seen it coming. Now, it is of course very difficult for the court to review these cases without reflecting on the awfulness of the events involved, and it does appear that the European Court was not able to do such a thing, because the court ended by saying this: the essentially debasing character of rape is so manifest that the result of the decisions of the Court of Appeal and the House of Lords, that the applicant could be convicted of attempted rape, irrespective of his relationship with the victim, cannot be said to be at variance with the object and purpose of Article 7 of the Convention, namely to ensure that no one should be subject to arbitrary prosecution, conviction or punishment. What is more, the abandonment of the unacceptable idea of a husband being immune against prosecution for rape of his wife was in conformity not only with the civilized concept of marriage, but also, and above all, with the fundamental objectives of the Convention, the very essence of which is respect for human dignity and human freedom. Now, despite those laudable words, it can still be argued that the European Court misses the point there, that the legal question for the court was not whether the abandonment of the exemption was in conformity with the wider essence of the Convention, which it clearly was, but the question of whether that decision had retrospective effect. And that was a different decision. But there you go. Imagine the alternative politically, though, a headline that the European Court prevents the United Kingdom's highest court from locking up rapists does not really bear any political contemplation. So maybe I just say by way of comment that the court was between a rock and a hard place in that respect. So that's the European dimension. Let me end with a postscript on the domestic level, the case of R. It does seem to me that the House of Lords actually had an alternative course of action open to them, which might have been less controversial in a legal sense. The option I suggest might have been open to them was to find that the accused's behaviour fell within the type of behaviour that the courts had already ruled was outside the marital exemption, namely that the wife, by leaving her husband, had effectively withdrawn whatever implied consent may previously been present as a result of their marital contract. Had they done this, I just included it within the current exemptions or by extending those exemptions, they would have enabled the conviction of Mr. R with a much reduced claim for retroactivity, and would have at the same time left the elected Parliament with the chance to remove the exemption as the Law Commission had, at that time, recently recommended. But what do I know?